friends, we have some new developments in the Doomsday Cult Mom case. Lori Vallow is moments away from a hearing in an Idaho courtroom. She faces charges of child abandonment, and it's happening right now, and we're going to go there live.
Thank you. Please be seated. All right, before we get started, I'm going to review one thing for the audience here today regarding disruptive behavior. Any activity or behavior which is considered disruptive by the court will result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance of the court proceedings may be removed from the courtroom and or the building at any time at the discretion of me or court security. We'll now call the case. Madison County Magistrate Division of the District Court, CR 3320-302, State of Idaho versus Lori Noreen Vallow. Counsel for Ms. Vallow appears at the defense table. We have Ms. Elcox, Mr. Webb, and Mr. Means. Counsel for the state is Mr. Wood and Mr. Rammel. This is the date and time set for an initial appearance. The defendant is also present here in the courtroom. Counsel for defense, in the court pleadings, it designates Ms. Vallow, aka Ms. Daybell. How would your client like to be referred to by the court?
Mrs. Daybell, please, Your Honor.
Right. Ms. Daybell, do you read, speak, and understand the English language?
Yes.
Ms. Daybell, did you fill out a notification of rights form with your counsel prior to the hearing here today?
Yes.
Do you understand your legal rights here today?
Yes.
Do you have any questions about the form that you filled out or your rights?
No.
All right, we'll proceed forward then. Ms. Daybell, it's my understanding that you've hired these three attorneys that are with you here today, and that's your position that you'd like to retain your own private counsel. Is that correct?
Yes.
Did you get a copy of the criminal complaint as well as the arrest warrant that has been issued in this matter?
Yes.
Ms. Daybell, I can read the criminal complaint in its entirety, or we can summarize it going through each of the charges. Which would you prefer?
We will waive a formal reading, Your Honor.
We'll just go through the counts then, one by one, as well as the penalties. This criminal complaint was filed here in Madison County on February 18th, 2020. It is State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. It charges the defendant with 5 different counts. The first count is desertion and non-support of children or spouse. That count is a felony under Idaho law, Idaho Code 18-401, Section 1. The punishment is up to a 4-year maximum imprisonment in the state penitentiary and or up to a $500 fine. It designates or alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 23rd of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, JV, date of birth 5/25/12, who was dependent upon the defendant for care, education, or support with the intent to abandon JV. Ms. Daybell, do you understand what count 1 alleges as well as the maximum penalties?
Yes.
Under count 2, it is that same charge, desertion and non-support of children or spouse. It's also a felony under Idaho Code 18-401, subsection 1. It is punishable by up to 14 years in the state penitentiary and or up to a $500 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 8th day of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, TR, with a date of birth of 9/24/2002, who was dependent on the defendant for care, education, or support with the intent to abandon TR. Ms. Daybell, do you understand what's been charged in count 2 as well as the maximum penalties?
Yes.
Ms. Daybell, count 3 is a misdemeanor under Idaho law. It's the charge of resisting and or obstructing an officer, a violation of Idaho Code 18-705. It's punishable by up to 1 year in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Vallow, aka Lori Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, did willfully delay and or obstruct a public officer, to wit, Lieutenant Ron Ball of the Rexburg Police Department, in the discharge of his office by giving false information regarding the whereabouts of a child, JV, date of birth 5/25/2012, and thereby delaying the search for JV. Ms. Daybell, do you understand the charge in count 3 as well as the maximum penalties?
Yes, I understand the charge.
Count 4 is also a misdemeanor. It's a charge of solicitation. It carries with it up to 6 months in the county jail and a $500 fine. It's a violation of Idaho Code 18-2001. It alleges that the defendant, Lori Vallow, aka Lori Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, with the purpose of promoting or facilitating the commission of a crime, encouraged and or requested Melanie Gibb to engage in conduct which would constitute the crime of resisting and or obstructing an officer. By requesting and or encouraging Melanie Gibb to give false information to law enforcement regarding the whereabouts of a child, JV, date of birth 5/25/2012. Ms. Daybell, do you understand the charge of count 4 as well as the maximum penalty?
Yes.
The last count is count 5. It's a misdemeanor under Idaho law. It's a charge of contempt, a violation of Idaho Code 18-1801, subsection 4. It's punishable by up to 6 months in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Vallow, aka Lori Daybell, on or about the 30th day of January 2020, in the county of Madison, state of Idaho, did willfully disobey a lawful court order in Madison County, case number CV 3320-45, by failing to physically produce minor children JV and TR to the Rexburg Police Department and or Idaho Department of Health and Welfare within 5 days of service of the order. Ms. Daybell, do you understand what's been alleged in count 5 as well as the maximum penalty?
I understand.
Ms. Daybell, do you understand that all of those charges and their maximum penalties could run consecutively, one after the other, or they could run concurrently, meaning at the same time? Do you understand that?
Yes.
In addition to the rights form that you've already filled out, pursuant to Idaho Criminal Rule 5, I'm also going to give you the following rights. Number 1, you are not required to make a statement, and that any statement made by you today can be used against you in court. Number 2, you're entitled to know the nature of the charges that have been brought against you, which we've already gone through. Number 3, you are entitled to bail. You have a right to bail. Number 4, you have the right to be represented by counsel. Number 5, you have a right to a preliminary hearing. That preliminary hearing must be set within 14 days if you're incarcerated. It can be set within 21 days if you're not incarcerated. That preliminary hearing is a probable cause hearing where the state will have the burden of showing probable cause that the 2 felonies have been committed in order for you to be bound over to the district court. You also have the right to communicate with counsel and immediate family, and that reasonable means will be provided for you to do so. Do you understand those legal rights, Ms. Daybell? All right, Ms. Daybell, now we'll schedule the preliminary hearing. I've met with counsel in chambers prior to coming out here, and there's a few dates that I believe did work. Mr. Wood, on behalf of the state, you designated that the state needs approximately 2 weeks to be ready, is that correct?
Yes, Your Honor.
And you also designated that the state needed 2 days for the preliminary hearing to take place, is that correct?
Yes.
Does the defense want to comment as far as how much time they need to be ready, as well as how much time the preliminary hearing will take?
Your Honor, I think 2 weeks is more than sufficient, and I agree with the proposed 2-day setting.
All right, the court has available March 18th and 19th. Does that work for counsel for the defense?
We'll make it work, Your Honor.
Does, Your Honor. Your Honor, the state may have an issue getting one of our witnesses over here from Hawaii on the 18th. We had asked previously that it be set for the 19th and 20th, and would continue that request.
Mr. Wood, if we made some arrangements so that if your witness could only be here by the 19th, that we allowed that witness to testify on the 19th, would that appease your concern?
Yes, Your Honor.
Does the defense have any objection to that, to moving things around a little bit so that that witness can testify on the 19th and not on the 18th?
No, Your Honor.
All right. We'll schedule then the preliminary hearing for March 18th and 19th here at the Madison County Courthouse. We'll schedule that right at 9 a.m. The court notes that there was a motion for a bond reduction that was filed by the defense in this matter approximately 2 days ago. Has the prosecution received a copy of that motion to reduce bond?
Yes, Your Honor.
Mr. Wood, is the prosecution objecting to that being heard here today?
No, you're not. No, we're not, Your Honor.
All right, we'll hear the motion to reduce bond then today. Ms. Elcox, are you going to be arguing that?
Yes, Your Honor.
You may proceed with your argument. I want you to know that I have reviewed your motion. I've also reviewed Title 19, Chapter 29, and Idaho Criminal Rule 46.
Thank you, Your Honor. Your Honor, we are asking that the court today set bail in the amount of $10,000 consistent with what Lori's attorney in Hawaii requested. In the event that the court is not inclined to set bond in the amount of $10,000, we are asking that the court consider setting a bond no higher than $50,000 in this case. Lori is presumed innocent as she stands before the court today. The fact that she is presumed innocent is not a loose guideline. It's a foundational principle of the American criminal justice system. Under both the 8th Amendment to the United States Constitution and Article 1, Section 6 of the Idaho Constitution, excessive bail is prohibited. Judge, you are the gatekeeper in this case. You're the guardian of the presumption of innocence and the constitutional rights afforded to Lori. This is not a court of public opinion. This is a court of law. And are we going to let our citizens' rights be dictated by what appears in the media? Bail must be set in an amount that assures Lori's appearance in court and is commensurate with the charges that she is actually facing today in court. A $5 million bond is unreasonable, it's astronomically excessive, and is the functional equivalent of holding Lori without bond. This is a violation of Lori's constitutional rights. I can tell the court that in my almost decade of practicing law as both a prosecutor and a defense attorney, I have never seen the crime of desertion charged. This is because abandonment issues are generally dealt with under the Child Protection Act, not the criminal code. But even under the desertion criminal statute, which Lori has been charged with and faces these charges here today, the maximum fine, as Your Honor said today in court, that can be ordered is $500. Yet her bail is set at $5 million, 10,000 times the maximum fine in this case. In a recent Madison County murder case, the bond was set at $1 million. In the 5 counts the court read today, charged in the criminal case, there is not one allegation of a crime of violence. A bond set this high denies Lori due process and fundamentally deprives her of her ability to meaningfully participate in the defense of these allegations she faces. It is clear that the government just needed to find a charge that would fit in this case because of all of the media attention surrounding this matter. The last thing that should happen is to allow this case to be tried in the media and to allow public opinion and rampant speculation to dictate how this case proceeds through the judicial system. Considering the purpose of bail, to which Lori is entitled as a matter of right, Idaho Criminal Rule 46, as Your Honor referenced, lists the factors that the court should consider when determining the appropriate bail amount to set in this case. Pursuant to those factors, Lori's bond should simply be reduced in the amount requested because she has no criminal history whatsoever. In fact, Lori took the initiative while she was in Hawaii to contact law enforcement and say, in the event that a warrant issues, she will voluntarily turn herself in. Police did not afford her that opportunity to do so. They created a spectacle out of the situation when they knew that Lori had contacted law enforcement and indicated that she would turn herself in. She waived extradition in this case. She did not fight returning to Idaho. She has hired 3 criminal defense attorneys from 2 different law firms, and she is dedicated to vigorously defending against these allegations. We, as her attorneys, also agree to assure Lori's presence in court. Chad, Lori's husband, has returned to Idaho to his home of his own volition, and Lori and Chad maintain a residence locally. That home was purchased over 5 years ago, or approximately 5 years ago. Chad, their children, their children's spouses, and their grandchildren are all located locally. Furthermore, Lori's passport is expired. She has no flight risk whatsoever, and this assertion that when this investigation began, when there was initial law enforcement contact, that she fled to Hawaii is unequivocally false. That was a planned move. We believe that the evidence will show that, will establish that. It was a planned move to a place that she had previously lived, and she moved to the exact same neighborhood in which she previously resided. Furthermore, Lori's history demonstrates that she has a consistency in her residences. She lived in Austin, Texas for almost 20 years, worked at the same salon for 15 years. She then moved to Chandler, Arizona, where she resided for 5 years in the same house. She worked as the director for Broadway Kids, an organization that puts on summer camps for children, and she also taught group fitness. Between 2014 and 2018, she lived in Hawaii until she returned there this fall. Lori's history demonstrates that she has consistent, long-term residence and a long-term employment in those places that she's lived. Further, Your Honor, there is probably no greater assurance that Lori will appear before this court and any other court assigned to preside over this case because of the droves of people that she has following her every move, even before she was charged. She has TV cameras in her face. She has people following her. It is built-in pretrial monitoring to a level I have never seen before. It's more effective than any sort of surveillance that law enforcement could put on her. She could not go anywhere without cameras and people scrutinizing her every single move. She poses no flight risk whatsoever. She is intent on defending against these allegations and proving that she is innocent, despite the fact it's the state's burden to prove her guilty beyond a reasonable doubt. If the intent of the high bond as originally set in this case was to ensure that Lori was transported back to Idaho, she is back. And as I stated, she is eager to defend against these charges. Regardless as to whether she has been tried and convicted in the court of public opinion, Your Honor, here today, Lori is innocent. Lori will absolutely abide by any pretrial release conditions, any sort of monitoring that the court requires, but there is simply no basis for a bond this high, and it must be reduced given the charges that she is facing. For those reasons, Your Honor, we would ask that you grant the defendant's request to reduce bond.
Ms. Elcox, just so I'm clear, if your client were to bond out, I don't need her address, but where would be her expected place of residence be?
She'll be residing locally, Your Honor. I can provide that address to the court under seal if the court would like to do so, but given the media attention, I would rather not put that on the record.
I understand. Thank you. Mr. Wood, do you wish to be heard?
Yes, Your Honor. I'll address counsel's comments first on how we got here and why the bond for the bail was set at what it's at. This case didn't start as a criminal case, Your Honor. It started as a report of 2 missing children who are still missing. November 25th, Rexburg Police, late in the day, get notice that this young child is missing. Within 24 hours, they respond. When they respond, they're given verifiably false information by the defendant. And so the next day, they obtain warrants and to search the residence for the child. And at that point, the defendant is gone. Now, they say it's a planned move. Maybe they did plan to move to Hawaii. However, they clearly left very quickly as soon as they were contacted by law enforcement. The vast majority of their belongings were still in that apartment. And so the investigation continued. A Child Protection Act was filed, and an order was given for Lori to produce the children, for the defendant to produce the children, which she did not do. I'll address this issue that she informed law enforcement that she would turn herself in. It's kind of hard to trust someone to turn themselves in on a warrant when a simple welfare check caused that person to leave. Your Honor, as counsel stated, Idaho Criminal Rule 46 lists the factors to be considered at setting bail. So we'll go down through those. The defendant's employment status and history. As far as we're aware, she's not presently employed. No argument can be made that she's at a risk of losing employment. Their financial condition. We are aware that the defendant's new husband received a substantial sum of life insurance proceeds from the death of his wife last October. Obviously, those funds provide them with the ability to relocate quickly and to stay away from Idaho, which we believe they've already done. The nature and extent of the defendant's family relationships. The defendant's only family here is her new husband. And it's important for the court to consider that at a bail reduction hearing in Hawaii, very recently, the defendant's attorney represented to the court that her husband lived in Hawaii, not in Idaho. Now, we understand that the defendant does have a house here, close to here. However, the fact that the defendant represented to a Hawaii court that they lived in Hawaii shows that they consider their ties not in Idaho, but in Hawaii. And in terms of her past residences, if we go back to the last year, it gets a little more concerning. In regards, since this last summer, the defendant has lived in Arizona, Idaho, and Hawaii. And quite frankly, the circumstances under which she left Arizona, which was soon after the killing of her estranged husband by her brother, and the circumstances in which she left Idaho, which was the same night Rexburg Police did a welfare check on her, give the state serious concern that she is a flight risk. Factor 4 is the defendant's character and reputation. Since this last summer, there has been a clear and alarming pattern in the defendant's life. There are literally 3 active investigations of suspicious deaths that she is related to. And I want to be clear, Your Honor, we're not saying she's been charged in those. And we're not saying the court should treat her as such. However, she is related to each of those deaths, and it is alarming to the state. As we've said before, Your Honor, the defendant tried to mislead Rexburg law enforcement about the whereabouts of her children. In furtherance of that, she tried to convince a family friend to tell the Rexburg police that the children were with her in Arizona, even though they weren't. And that, Your Honor, the defendant has a history of defying court orders. In the child protection case associated with this case, she refused to produce her children as ordered. In a 2009 child custody case in Travis County, Texas, the defendant was found guilty of 7 different counts of civil contempt. Factor 5, the persons who agreed to assist the defendant in attending the court at the proper time. Again, Your Honor, that's pretty much limited to her new husband. And due to the fact that he and the defendant left so abruptly before, we don't have a lot of assurance from that. Factor 6, the nature of the current charge and any mitigating or aggravating factors. that may bear on the likelihood of conviction and the possible penalty. In regard to those factors, Your Honor, the state would first point out the language of Idaho Code 18401, which states that it is a felony for anyone having a child under the age of 18 years dependent upon him or her for care, education, or support, who deserts such child in any manner whatever with intent to abandon it is a felony. In any manner whatever. That's a broad statute, Your Honor. It's broad because it deals with protecting children. So the aggravating factors bearing on the likelihood of conviction in this case include the following: that the defendant established a residence in Madison County, Idaho, with 2 minor children. Those children ended up being reported as missing, and the defendant left the state without them. The defendant defied a court order to produce those children. One of those minor children is only 7 years old and has special needs which require medication and medical attention. Both of the minor children received Social Security benefits, and the defendant continued collecting the children's Social Security benefits into her own account, both after the last known sightings of the children in Madison County and continuing into Hawaii. And it's important to note that case law related to the desertion of a minor child and Idaho Code 19302 make it clear that this court has jurisdiction over acts of desertion both here in Madison County and continuing into Hawaii. And the most aggravating factor, Your Honor, one that's quite frankly heartbreaking and is the reason why there's so much media attention, is that the children are still missing. And the defendant has not only misled law enforcement in their efforts to find the children, but she has completely and utterly refused to aid in any attempts to find the children, even before charges were filed. Another factor bearing on the likelihood of conviction is the Idaho Code 18403 and 18405 and case law related to the statute under which she was charged make it clear that proving abandonment or desertion is prima facie evidence that the desertion was willful, which makes it easier for the state to obtain a conviction. In regards to the sentence, should the defendant be convicted, and we believe she will, the defendant could face up to 30 years in prison, which is certainly a motive to flee. As far as the defendant's prior criminal record, Your Honor, as we aren't aware of any criminal history. However, as we discussed earlier, she does have a history of defying court orders. Factor number 8, any facts indicating the possibility of violations of law if the defendant is released without restrictions. And Your Honor, we would just say past behavior is the best predictor of future behavior. She's already disobeyed this court's order, and so we have no reason to believe that if she were released that she wouldn't continue in unlawful behavior. Factor 9, any other facts tending to indicate that the defendant has strong ties with the community and is not likely to flee the jurisdiction. At this point, Your Honor, with her 2 children missing, the defendant's only local tie is her husband, who again, as of a couple of weeks ago, she claimed that he lived in Hawaii. Factor 10, what reasonable restrictions, conditions, and prohibitions should be placed on the defendant's activities, movements, associations, and residences. Your Honor, should the bail be lowered or should the defendant be able to make bail, we would ask for the following restrictions: that she be limited to living in Madison or Fremont County, Idaho, that she be required to wear some sort of GPS location device, and we're aware that those can be obtained from a bondsman, and that the defendant, if she does have a passport, that she surrender it to the court. In conclusion, Your Honor, the defendant has established through her own behavior that she cannot be trusted to obey a court order or to appear at future court hearings. The state believes that bail should be confirmed where it is. We have no confidence that the defendant will stay in the area and appear for future hearings should she be released.
Thank you, Mr. Wood. Ms. Elcox, this is your motion. I'll give you the last word if you'd like it.
Thank you, Your Honor. As I indicated, Lori is more than willing to abide by any restriction that the court puts on her if the court so chooses to do so. The prosecutor stated that past behavior is essentially the best predictor of future behavior. I would point to the fact that Lori, in all of the decades that she has been alive, does not have a single criminal law violation whatsoever. It goes without saying that she also does not have any failure to appear in any criminal case. The prosecutor referenced the specific code language that she is charged with. I would note that this statute doesn't have a definition for abandon. However, the Child Protective Act does. And in that In those statutes, the prima facie evidence of abandonment is established when there hasn't been the parental relationship hasn't been maintained for a year. Pursuant to the charging language and the time period that the state chose to charge in this case, Lori isn't even at half that time. So I respectfully disagree with the prosecutor's assertion that Lori will be convicted of these charges. I have represented to the court, as I have a duty of candor to the tribunal, that Lori will be residing locally. And as I indicated, I'm happy to provide that address to your honor under seal to protect Lori in this case. The prosecutor has gone through a litany of allegations for which she is not facing any sort of criminal charges whatsoever, and not criminal charges in this case. Those should not be considered by the court for purposes of this case and setting bond pursuant to Idaho, the factors listed in Idaho Criminal Rule 46. We would ask that you grant the defendant's request and set bail as requested in this matter.
Thank you, Ms. Alcox. Court has listened carefully to the argument of both the state and the defense. The court has reviewed in detail and in full Rule 46 of the Idaho Criminal Rules. The court has also reviewed the Idaho Bail Act, Title 19, Chapter 29, specifically under 1929-04. It designates that the court may release a person on his own recognizance or set an amount of bail, and may impose any conditions of release. In making these determinations, the court shall consider the following objectives. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Number 3, ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court has taken all 4 of those factors into consideration, as well as all 10 factors under subsection C under the Idaho Criminal Rules 46. And based upon the argument that I've heard here today, the court is going to reduce bail. I'm going to reduce bail to the amount of $1 million. I recognize all of the factors that have been looked at here. One specific thing that the court notes in setting such a high bail amount is that there is a pending court order, and to my knowledge there has been nothing set forth regarding obedience to that court order pertaining to lining the court out with information on where the 2 children are at the Department of Health and Welfare or at the Rexburg Police Department. So with that, bail will be set at $1 million. If bail is posted, there will also be the following conditions that are ordered. Number 1, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number 2, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state, this country, this county, and this city. Mr. Wood, do you have any questions about my ruling regarding the reduction of that bail?
No, Your Honor.
Ms. Alcox.
Just briefly, Your Honor, does the court have a specific form for the waiver of extradition you would like us to use?
I think the jail has one. Does the jail have a form that they have? If you'll communicate with the jail, I think they do have a form. If not, why don't you submit the one after you've gotten approval from Mr. Wood? you can submit that after she signed it, and the court will review to make sure it meets my satisfaction.
Yes, Your Honor. And do you have, would you like us to coordinate setting up the ankle monitor through the jail, or do you have a specific agency you would like us to use?
You can coordinate with the jail and or the sheriff's office. They'll know that information. They may have someone that they usually use. I'm not sure of that. If you have a preference, you could provide that information to them, and if there's an issue, it can be brought before me for my
Thank you, Your
approval. Any other questions?
No, thank you.
I believe that takes care of everything that we're here for today. In a moment, I'm going to leave. When I do that, the audience is going to be asked to rise. I'm going to leave the courtroom. After I leave, I'm instructing everybody to be seated again. There will be the removal of the defendant from the courtroom, and then everybody will be excused row by row pursuant to court personnel here today. With that, we'll be in recess.
All right.
And there you have it. The defense asked for $10,000 bail. The prosecution asked for $5 million, and the judge set the bail at $1 million. Still with me on set, my colleague Julie Grant. Julie, what are your thoughts on the bail amount of $5 million being requested, but $1 million being settled on?
I'm mad, Seema. I didn't want that bail amount touched, reduced at all. If anything, if the judge was going to make an amendment, I would have said, make it no bail. Hold her with no bail.
How can he justify $5 million bail?
I think because those children are still missing and they may be in danger. What if those children are still alive? And what if I'm on the prosecution side, the argument I would make is that, let's just say they're still alive. We haven't found bodies. What if she makes bond and then goes and finishes the job? What if she wants her kids dead? I mean, the behavior she's exhibiting seems like she doesn't care if the children are alive or dead.
I just want to point out, Julie, so we're still have live pictures inside the courtroom. We believe that the gentleman in the middle, he's got the white shirt, blue tie, is the husband of the now Chad Daybell.
Chad Daybell.
Yeah, so we're still watching inside the courtroom. Everybody's seated because, as the judge said, he leaves. Everybody has to stay calm. And I want to also illustrate that before court today, our Grace Wong, our producer, and boss, but Grace said that the public interest was so high that people had been lining up hours before just to get a seat.
Yes.
And there's only about 70 seats in the courtroom, and that people had to actually get a number.
Yes, Seema,
to get a seat.
right.
So it was really hard to get a seat.
Grace Wong shared a great story that there are sisters there. One is age 20, one is age 15, and their little brothers, who are ages 7 and 8, were students of Tammy Daybell, Chad Daybell's first wife, who, by the way, died mysteriously 2 weeks before Lori Vallow and Chad Daybell got married.
Okay, so I want you to tell the rest of the
Sure. Why I'm
saga.
mad about the bond reduction?
Well,
or,
about this, because she
yes.
sounds like a female Durst.
Yes, Seema, yes. You're so right about that. You're absolutely right. And why you're saying that is because we know there are 3 bodies the state is trying to link to Robert Durst. Well, guess what? If we had to predict, there are going to be 3 bodies it seems investigators may try to link to Lori Vallow and Chad Daybell. And I'll explain. Vallow's estranged husband, Charles Vallow, the father of the children, shot and killed in Phoenix last July by her brother. His name was Alex Cox. And by the way, Lori Vallow and her daughter Tylee were in the home at the time that her brother killed the child's father and her husband. Apparently, he said that the husband had swung a belt at the back of his head, so he went and got his gun, and he shot him in the house. So then after that happened, Alex Cox claimed the shooting was in self-defense. That happened in July. Then
And
fast
was
forward,
Alex Cox arrested and all that for that?
I don't believe so. I believe nothing had happened in the way of charging, but I'm not positive. I know that he died of unknown causes in December, which has raised a lot of eyebrows and questions.
Cox.
Alex Cox. So now husband, Lori Vallow's estranged husband dies, brother dies.
But
then
the brother died of unknown causes. Isn't he a young guy?
it's mysterious. Right. I'm not sure of his exact age at the time he died, but
Yeah, I think
yes.
just looking at her, he's got to be a little.
It's suspicious.
He can't be that old.
Right, Seema, very suspicious. Then Vallow moves her family to Idaho, where she is now, and before the court today. That happened in late October. Chad Daybell's wife, Tammy Daybell, the teacher who the sisters of her students were there today, she dies of natural causes. So again, very suspicious. And then 2 weeks after Tammy Daybell's death, her husband is marrying this woman here in the jumpsuit.
Is anyone investigating Tammy's death? Oh, wow, she was laughing there before. Okay.
Yeah, look at her.
Yeah, wait, was she, this story is baffling.
Like you always say bananas. I thought you were going to say bananas there.
This
Right,
is bananas.
it really is.
But is anyone investigating Tammy's death and Alex's death?
I sure hope so. And you know this, Seema, you've been in criminal practice a long time. One thing I learned is investigators are always further along than they let the media and the public know. And they have to be for public safety, for sake of the case and getting it right. So I have a lot of faith in the men and women in law enforcement, in the local communities, the federal enforcement, the FBI, federal law enforcement now involved in this case, sharing those pictures, doing that public request for information. I think that between the feds working the case and the local officials working it, I think we're going to get some answers real soon. I think more people are going to be dragged into court.
Now, Lori and Chad are part of the cult, but was Tammy and her ex-husband or the brother, were any of them in the cult?
Not that I'm aware of. That's what's really weird. Not that I'm aware of this. And Doomsday is happening sometime in July of this year. So what's supposed to happen then? What do they think will happen?
Well, the end of the world.
Yeah, right. Yeah. For her, I just hope she's still locked up and poses no danger to those children if they are still alive. Because if we have faith and all the prayers that have been coming out for these children, if they are still alive, if I'm the prosecutor, I'm going to say there's a danger in her potentially harming them if she gets out. That's why I'm angry that bail was reduced.
Okay, but just to be clear, she is facing 30 years in prison. Again, I think that is part of the judge's decision-making on keeping it at $1 million, because let's say she was facing life in prison, perhaps then he had justification to increase the bail. She will have an ankle monitor, which makes me believe that she's going to make the $1 million bail. She's also, in the arraignment, was represented by, I think, public defenders, but she's going to have a private counsel. Where is this money? Do we know where this money is coming from, that she's getting private counsel and...
Right. Don't know for sure, but I could venture an educated guess. We know
I.
that Chad Daybell got a nice sum from a life insurance policy when his wife mysteriously died. So perhaps that's funding counsel for her. Seema.
That's what bothers me. Okay, so if there's an investigation into Tammy's death, my opinion is nobody should be getting any life insurance policy.
Right.
Right? Because if they're investigating it as a suspicious death, then why is he even getting any money? They should put a hold on that until it's been determined whether she died of natural causes.
You make an excellent point, Seema. Maybe there was no investigation at the outset. Maybe it went unnoticed. And now with all of the attention drawn to this case, maybe now they'll go back. It's not too late.
No, you're right. You're right. So, and then it would be like a restitution.
Right.
Whatever he gets.
So maybe, that's going to go right back. This is really some sick stuff. I think. Was it as disturbing to you? I'm sure it was, as it was to me, watching her. And there is
Can we talk about the lipstick?
Oh,
she has more makeup than we do. We're on television.
I know, right?
She had lipstick and eyeliner and blush, and I saw her rolling her eyes.
Right.
And she was so curt and nasty when the judge asked her, "Oh, do you understand the charges?" Yeah, I do.
Right. No bit of concern. I mean, could you imagine if you are a parent and your children are the people you love more than anything in this world, and they are missing and they vanished like they were plucked, right out of Idaho, and who knows where they are? I mean, and you're in Hawaii, first of all. Like the last thing you'd think somebody who truly cares about their kids would do is go on vacation to Hawaii, but then here she is in court, not a tear.
But it sounds like she went on vacation to Hawaii after she got rid of the kids.
Yep. That's why I just think she needs to be in jail. She needs to be locked up. Oh, well, yeah, and she may be. They'll absolutely evaluate her if they haven't already.
She really, I think, folks, we are looking at inside the criminal mind. I mean, I think she just looks like a through and through criminal.
Right.
Narcissist.
Yes.
she's just, it's just reeking from her face and her facial expressions.
Yes, Seema. It's scary. I mean, think about it. And those children, like, I think the better argument the defense could have made for a reduction in her bail is that she wants to go look for her kids. She wants to be part of this search effort. If I
that's
was on the
good.
defense side, I would have been like, look, she is devastated about this. She
That's
wants to
really
help.
good.
That, to me, would have been a
Well,
better
the
argument
def-
before the court
defense
than no
attorney
criminal record.
Talked for 20 minutes and did not include any of that. Julie Grant, thank you for working late tonight
My
and sticking with
pleasure.
us. We
Thank you
really
for having me,
appreciate it.
Seema.
Absolutely.